J'invite maintenant le professeur Peirs d'Argent à prendre la parole. Vous avez la parole.
Je vous remercie, Monsieur le Président. Monsieur le Président, Madame la Vice-présidente, Mesdames et Messieurs les juges, c'est un grand honneur pour moi de prendre la parole devant la Cour et de le faire aujourd'hui à l'appui de la noble cause soutenue par la Gambie dans le différend qui l'oppose au Myanmar. Il me revient d'examiner la deuxième condition à laquelle est subordonné l'exercice du pouvoir de la Cour d'indiquer des mesures conservatoires. Cette deuxième condition est relative aux droits revendiqués qui, selon la Gambie, requièrent de manière urgente protection. La jurisprudence de la Cour sur ce point est bien établie. Et ainsi que vous l'avez encore rappelé le 14 juin dernier, il y a lieu de déterminer si, je cite, les droits revendiqués dont la protection est sollicitée sont des droits plausibles compte tenu de la base de compétences prima facie de la Cour en l'espèce. Partant, les droits allégués doivent présenter un lien suffisant avec l'objet de l'instance pendante devant la Cour.
Normative character of the Genocide Convention as they arise from your own jurisprudence, I will more clearly address the rights which are the subject of this judicial proceedings and which Gambia is requesting the protection of. And that is the nature of these rights will clearly arise before you. I will point out that in Article 41 of the statute, nothing denies the court's jurisdiction in ordering provisional measures when the rights claimed are of the nature of those under the convention. Mr. President, in the consultative opinion of 1951, the court addressed what it called the special characteristics of the Genocide Convention, and it pointed out, and I quote, the intention of the United Nations to condemn and punish genocide as a crime under international law involving a denial of the right of existence of entire human groups, end of quote. This right, the right of existence of the Rohingya human group, is a right which Myanmar is bound to show respect for, and thus also to respect those rights for all state parties to the Convention on Genocide. By addressing the court, Gambia is attempting to protect the right of the Rohingya group to exist, nothing more and nothing less. The nature of the rights enshrined by the Convention is closely tied to this object, and thus by examining these, the court pointed out that in such a convention, the contracting states do not have interests of their own. They merely have, one and all, a common interest, namely the accomplishment of those high purposes which are the raison d'être of the convention. Consequently, in a convention of this type, one cannot speak of individual advantages or disadvantages to states or the maintenance of a perfect contractual balance between the rights and duties. End of quote. Since that date, the court has pointed out that the specific provisions of the Convention clearly say that the rights and obligations enshrined by the Convention are rights and obligations erga omnes. Furthermore, the court has pointed out that the norm prohibiting genocide was surely a peremptory norm of international law, jus cogens. There is therefore no doubt, Mr. President, ladies and gentlemen of the court, that the Gambia indeed is rightfully invoking the responsibility of the respondent for breaches in the convention. In fact, the Convention Against Torture is something that you pointed out, saying that the obligations were erga omnes partes, and therefore state parties to the convention could invoke the responsibility of another state party with a view to ascertaining the alleged failure to comply with such obligations. And as the court pointed out, it is in the common interest of the state parties that there is compliance with the relevant obligations under the convention, and that is what justifies that all states should be able to invoke the responsibility of any other state for a breach in the knowledge that, and again I quote the court, if a special interest were required for that purpose, in many cases, no state would be in the position to make such a claim.
obligation.
In 2012, the court ruled on the subject of erga omnes partes obligations when it came to the Convention Against Torture, and that would be even more so. The same should apply, as we all know, since the Barcelona traction case on the subject of the Genocide Convention as well. The court has characterized as erga omnes obligations these obligations as well, and every state can invoke the responsibility of another state for breach of the special obligations of the Genocide Convention without having to justify a particular interest. In reality, the state that invokes the responsibility of another state for violation of the erga omnes obligation doesn't need to have a reason to do so. However, the interest is not of a specific nature, and this interest that is shared by all states is something that is shared. Mr. President, through the action that is instituted against Myanmar, the Gambia is implementing the right it holds to make sure that the convention is duly executed. The convention enshrines obligations, but also erga omnes rights. And these rights are the exact reflection of these obligations. Collective obligations of the conventions are associated for rights for each contracting party to ask and obtain its execution. Whereas the erga omnes character of the obligations represents the basis, the right of each state party of the convention consists in demanding the respect of primary legislation, that is to say, the duty of the responsible state to perform the obligation breached. It is therefore certain that Gambia holds rights that are its rights, and it wishes for the rights to be respected through this jurisdictional procedure. And therefore, it is entirely compatible with Article 41 of the statutes, because Gambia's right to have that Myanmar fully executes the convention is seriously imperiled due to the behavior of the defending state. Furthermore, by looking at protecting its right as a state party of the convention, the Gambia is also trying to ensure the protection and to use what the court said, the right of existence of an entire human group, that is to say, the Rohingya group. And in this respect, it is not necessary to determine whether the convention personifies groups or if individuals of that group are vested with these rights directly as members of protected groups' rights on which they could rely before the court. One can note that the main purpose of the objective is the safeguard of all national, ethnic, racial, or religious groups as such. And since the convention bars genocide as being total or partial physical destruction of such a group, it is essentially protecting the members to life and to physical and mental integrity. It is in this sense, therefore, that the Genocide Convention is very often considered as the very first modern treaty and that protects human rights. Each criminal act as defined under Article 2 is being infringed because it is a group that is protected through its members rather than through its heritage or its territory or cultural language. It is about human beings, men, women, and children who, due to the fact that they belong to that group, are protected by the convention, just like the group is protected by the convention. Therefore, the Gambia would like to enforce the respect of its own right so that all members of the Rohingya group subjected to the act of genocide are protected. And therefore, the court should declare that such a right is plausible, that is to say, it is grounded in a possible interpretation of the convention. And this is decidedly the case because by imposing on the contracting parties the obligation to prevent and to punish genocide, the Convention protects the groups that it targets as well as their members. In this respect, the beneficiaries of the rights provided by the Convention are not just the state parties, but also groups and their members. And it is their fundamental rights that are violated every time the Convention is violated. It is their rights that are protected by the Convention every single time when acts covered by the terms of the Convention constitute the acts that are likely to infringe the essential human rights. And thus, and I would like to quote the report of Judge Gaia at the International Institute for Law, who said, a group threatened with genocide has a right towards all the states that genocide should not be committed and be prevented and punished. Mr. President, honourable members of the court, the Article 41 of the statute enables you to protect the rights that the Gambia holds under the convention and also includes those of the Rohingya to not be exposed to genocidal acts. Therefore, the rights claimed and protected under provisional measures are the rights that the requesting party is asking for protection. That is to say, rights which are the subject of dispute in judicial proceedings. Therefore, protecting the rights forming the subject of the dispute submitted to the court while awaiting judgment as to the merits of the court. In the provisional measures in the Bosnia-Herzegovina court, the court recalled that these rights were protected on the merits, which might ultimately form the basis of a judgment. And Article 41 enables, therefore, that Gambia can solicit protection for all the rights which are the subject of the dispute. Any other conception would be tantamount to restricting in an absurd manner the incident jurisdiction of the court on provisional measures, an area in which it is dearly needed. The measures requested by the Gambia have the manifest intention to protect these rights and represent a link with the rights of which protection is requested, as Professor Sands will mention at the end of the hearing. Honourable President, ladies and gentlemen, I would like to thank you for your kind attention, and I would like to ask you to request Mr. Paul Reichler onto the rostrum, who is going to talk to us about the urgency and irreparable harm to rights claimed. Thank you very much for your attention.